3, 2, 1, start. In the administration of justice, it has often been emphasized that the court must strike a delicate balance between audio-altering pattern and ex parte urgency, ensuring that the principles of natural justice are never sacrificed at the altar of expediency. The maxim fiat justitiae ruat caelum, let justice be done though the heavens fall, embodies the uncompromising spirit of judicial responsibility. Yet, the judiciary is equally mindful of the doctrine of res judicata, so that no litigant may re-agitate matters already conclusively decided. In recent matters, the petitioner approached the court under habeas corpus, alleging that his detention was arbitrary, capricious, and in blatant violation of ultra vires limitations imposed by statute. The state, however, argued that the detention was justified under extraordinary circumstances of national security involving the doctrine of salus populi supreme lex esto, which declares that the welfare of the pupil shall be the supreme law. The bench, consisting of 3 honorable judges, scrutinized the prima facie evidence and concluded that the detention order lacked proportionality and procedural fairness, thereby directing immediate release. In another appeal, the appellant questioned the legality of certain administrative orders, which he claimed to be mala fide and lacking bona fide justification. The court, after an elaborate discussion, reiterated that the principles of state decisions must be respected, but when earlier precedents appear per incuriam, the court is duty-bound to correct the anomaly. The judgment also clarified that writ jurisdiction under Article 226 is wide but discretionary and not to be exercised in every trivial matter. Meanwhile, in civil disputes, parties have frequently relied on the doctrine of caveat emptor, meaning let the buyer beware. But modern consumer jurisprudence has diluted its rigidity by recognizing statutory protections. Similarly, the principle of mens rea remains central in criminal law, emphasizing that guilty intention must coincide with guilty act, expressed in the Latin maxim actus non fecit ream nisi, means sit rea. In the present environment, with growing complexities in commerce and technology, the judiciary is often called upon to interpret contracts containing verbose and sometimes incomprehensible clauses drafted with legalism of extraordinary prolixity. Judges have repeatedly warned against the indiscriminate use of archaic terminology and convoluted phraseology, which obscure rather than clarify the true intent of parties. In this context, the term obiter dicta gains significance as stray observations through persuasive cannot bind future courts with the same force as ratio decidendi. The court also deliberated on issues of locus standi, underscoring that access to justice must not be denied merely on the basis of technical objections, especially in matters affecting public interest. Public interest litigation have broadened the horizon of judicial review, enabling the voiceless to be heard through representatives. Although frivolous petitions are sternly discouraged, the principle of in limine dismissal was reiterated to filter out such vexatious litigation at the threshold. Finally, the judgment touched upon broader constitutional values. The court affirmed that liberty, equality, and fraternity are not abstract ideals but enforceable commitments. While acknowledging the necessity of occasional restrictions, it emphasized that such curtailments must always remain proportionate, reasonable, and consistent with democratic ethos. To quote the oft cited maxim, ubi jus ibi remedium, where there is a right, there is a remedy. The court held that remedies must be both accessible and efficacious, else the very existence of rights becomes illusory. Thus, the court concluded that constitutional morality requires both the state and the citizen to act within the boundaries of law, upholding justice not merely as a legal formality but as a living reality. Stop.